To move that this House has considered miscarriage of justice compensation. Now, Mr Turner, I should like to wager that the majority of citizens in this country are relatively unfamiliar with the workings of the criminal justice system, and less still with miscarriages of justice. Perhaps, if they are aware of miscarriages of justice, they'll be aware of certain high-profile exonerees or cases of miscarriage of justice, such as the Cardiff 3, the Guildford 4, or the Birmingham 6. However, most will understandably, and quite reasonably in my opinion, assume that victims of miscarriages of justice are compensated, particularly if they have spent time in custody before being pardoned or having their convictions quashed. However, this is not the case. For cases in England and Wales, compensation for the wrongly convicted is the exception rather than the rule.
It's not often that we talk on this podcast to someone who is still in the midst of their crisis, but that is the case today.
Well, actually, strangely enough, in the moment, it's like you're in a dream. You have an out-of-body experience, so it's not really happening to you, if that makes sense. You're sort of like looking at it as though you're not there, and you go into survival mode. And so, I would, if I was to have to describe my initial time in prison and post that sentence, you're in survival mode. But I remember obviously going down, being put in the cell. You'll be familiar with that. I mean, you were at the Old Bailey. I was at Southwark at that stage, although I did have to spend time in the Old Bailey as well at a later date. And your lawyers are allowed to see you. They probably came to see you, same thing. And I remember looking through that Perspex screen at them at that stage and just saying, I'm scared. I was so scared.
Tom Hayes is a former securities trader who was jailed, at first for 14 years, later reduced to 11, as part of the notorious LIBOR scandal in 2015. He served 5.5 years in prison, including a brief stint at HMP Belmarsh, a former address, of course, that we share. It's an experience that had and continues to have a severe impact on his life in so many ways.
Let that sink in. Expert consensus directly contradicts the prosecution, yet Ms. Betsy remains convicted. This should alarm every healthcare professional. The third wall inquiry must be suspended immediately. Truth demands a complete examination of all evidence, not a selective investigation designed to confirm guilt. Justice requires nothing less. The government's leadership must listen to all healthcare professionals raising concerns about this case. We are fulfilling our duty of candor, yet many nurses must remain anonymous for fear of retaliation. This is unacceptable. Make no mistake, suppressing nurses' voices directly endangers patients. When we cannot speak freely about concerns, patient safety is compromised.
Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Buckle up, because today's video is part of our explosive monthly news session, and what a month it's been for the criminal justice system. It's been taking hits from every direction, with flaws surfacing at every stage, from trials to appeals and even compensation battles. In this session, we will explore the latest developments on the cases of Brian Buckle, Tom Hayes, and Lucy Letby. Plus, we'll take a quick look at the CCRC and whether there has been any movement since its former chair stepped down in January. As always, stick with us until the end to get the full story and all the facts you need to shape your own verdicts. But before we start, my usual recommendation: subscribe if you haven't already, to support our mission to humanize the criminal justice system. Let's start this new session with some good news for a change. In our last news session, we mentioned how mainstream media are increasingly and timidly starting to support the struggles of wrongfully convicted individuals, particularly regarding compensation or the lack thereof. We are pleased to see that Brian Buckle's fight for justice has now been featured by BBC News in an article titled "Calls to Amend Payout Rules for Wrongly Convicted." Brian's wrongful conviction not only led him to be formally diagnosed with PTSD, but has also deeply impacted his loved ones. His daughter Georgia revealed that she struggled with suicidal thoughts during his imprisonment. After enduring an 8-year ordeal, he emphasizes the urgent need for reform in a broken justice system. He hopes for an apology and acknowledgement of the authorities' mistake. The article concludes with a few powerful words from Brian himself. "I will take what happened to me to the grave," he says. "Money is not going to change how I am mentally, but it's the principle, the justice system admitting that they got it wrong." The matter was also discussed in Parliament on Wednesday, 19th of March, in a Westminster Hall debate opened by Ben Lake, Brian Buckle's local MP, as highlighted at the beginning of this video. He said the issue in this debate is the failure of the state to right these wrongs.
Now, the unfairness of the current system was brought into very sharp relief for me, Mr Turner, when I met my constituent, Mr Brian Buckle, and his family, and learned of their experiences. And I'm very pleased to say that they have made the journey from Fishguard today to be with us in this chamber.
He then went on to explain how Mr Buckle dedicated over 15 years to his engineering role, commuting weekly between West Wales and London. However, his life was shattered by a wrongful conviction, stripping him of his freedom for over 5 years at His Majesty's pleasure, costing him his livelihood, pension and financial stability, and inflicting profound personal suffering beyond measure. Despite his eventual exoneration, the Ministry of Justice rejected the compensation claim, citing the 2014 legal change that requires the wrongly convicted to prove their innocence beyond a reasonable doubt, an unreasonable burden that contradicts the fundamental principle of being innocent until proven guilty.
So if I can return now to my constituent Mr Buckle's case. In its rejection letter, the Ministry of Justice, in addition to reassuring him that his case had been carefully considered, asserted that despite rejecting his claim for compensation, he is still presumed to be and remains innocent of the charges brought against him. Now, if you ever are looking for a definition of Orwellian doublespeak, Mr Turner, this response provides a perfect example of it in practice. And it illustrates the way in which the 2014 change, by reversing the burden of proof, undermines the presumption of innocence and forces the Ministry to perform quite impressive but illogical linguistic gymnastics. For if Mr Buckle is, in law, presumed to be innocent, then he must be treated by the state as such. A man presumed to be innocent who has spent over 5 years in jail should be compensated. And if the state wants to treat him as though he were a guilty man and deny him that compensation, why should the burden not fall onto the state to prove his guilt? So claims by the Ministry that Mr Buckle is still presumed to be and remains innocent of the charges brought against him ring rather hollow when he is also denied a single penny in redress. It's clearly an affront to justice that the eligibility test prevents those who have been wrongly convicted of enjoying the full and unconditional benefits of being presumed innocent.
In conclusion, Mr Lake urged the government to reconsider its approach and ensure fair compensation for victims of miscarriages of justice. He also urged the minister to meet and discuss both Mr Buckle's case and the necessity of legal reform. He added, time is critical. Justice delayed is justice denied. In her response, Alex Davies-Jones, the Parliamentary Under Secretary of State for Justice, said they, referring to those wrongly convicted, are victims of the state. So it is right that the state should help and support those people in rebuilding their lives. It is also right that we should seek to redress the occurrence of miscarriages of justice and to reduce them by learning lessons when things go wrong. She added, the Law Commission is currently consulting on a wide range of changes to the laws relating to criminal appeals. The consultation is rigorous with more than 100 questions, including questions on compensation for miscarriages of justice. We look forward to the final report in 2026 and we will consider all its recommendations in the round before deciding on any necessary reforms. However, interestingly, she took the time to clarify the government's stance on miscarriages of justice, stressing,
I feel it is important at the outset to clarify what we mean when we talk about a miscarriage of justice. The Court of Appeal is a vital safeguard in the criminal justice system. And if someone appeals their sentence within the time limit, which is normally 28 days, and the Court of Appeal overturns that conviction, then that is the system working as it should to correct any errors. That is not a miscarriage of justice. Our interest, and the interest here today, is in those who have exhausted that usual appeal process and have often referred themselves to the Criminal Case Review Commission. If the CCRC find that there is a real possibility that the Court of Appeal will not uphold the conviction, they will refer the case. If the conviction is then overturned, the person may have a qualifying miscarriage of justice for the purposes of compensation.
This interpretation strongly hints that if the Law Commission were to recommend compensation for those whose convictions are quashed on an in-time appeal, an issue raised in question 100 of their consultation paper, the government is likely to shut it down. That's hardly an encouraging start and seems at odds with the government's own plan for change referred in her opening remarks. Yes, the law sets a 28-day limit for appeals, but what she fails to acknowledge is that many people wait months, sometimes years, before their appeals are heard. During that time, they are already serving sentences, enduring the devastating consequences of wrongful convictions. And let's be clear, the early months and years of a sentence are often the most damaging. To suggest this is simply the system working is, in our view, misguided. The harm is done regardless of when an appeal is lodged, and denying compensation to those who suffer through this injustice just because their appeal was on time is indefensible. Returning to Brian Buckle's case specifically, she made no promises. She only said, I will ensure that the request for meeting is passed to the Minister of State, my honourable and learned friend, the member for Finchley and Golders Green, Sarah Sackman, who is responsible for this brief. Unfortunately, she cannot be here today as she is in the Assisted Dying Bill Committee, but I will ensure it is passed on. I will also take a keen interest in the case. We sincerely hope that Mr. Lake succeeds in securing a positive resolution for Brian and his family, who truly deserve an end to this painful and arduous chapter of their lives, one whose consequences they will undoubtedly carry forever. Just like in Brian Buckle's case, our next story also deals with the consequences of a flawed system, but with an entirely different twist. Tom Hayes recently shared his story in a podcast with Andy Coulson, as mentioned in our introduction.
Tom believes that his conviction was unjust, and in 2017 he launched an application to the Criminal Cases Review Board. After a long court battle, his appeal will be heard by the Supreme Court in March. In this episode, we won't be talking in depth about that case, that's for the courts. But we will be talking about the breakdown of Tom's family, his autism diagnosis, and how he handled the unravelling of what was an incredibly successful life.
It's a fascinating discussion, and I highly recommend listening to it, as it sheds light on critical issues such as neurodiversity and scapegoating within the criminal justice system. Hayes speaks candidly about living with Asperger's, navigating the high-stakes world of finance, and enduring life in some of Britain's toughest prisons. We have covered Tom Hayes' case in depth throughout this video and in previous news sessions. We can now confirm that his case has reached the Supreme Court, where it is set for a 3-day hearing from the 23rd to the 27th of March 2025. The Supreme Court will examine two key legal questions. Does a LIBOR or Euribor submission automatically constitute dishonesty if it is influenced by a trading advantage? Must a LIBOR or Euribor submission reflect the absolute lowest rate at which a panel or prime bank could borrow at the time? Or can it be selected from a range of potential borrowing rates? The convictions of Tom Hayes and Carlo Palombo rest entirely on whether there was an absolute legal prohibition against considering a bank's commercial interests when submitting LIBOR or Euribor rates, and crucially, whether traders were made aware of such a restriction. In our view, the answer is clear and lies in the regulatory reforms introduced after the LIBOR scandal. Before these changes, LIBOR was effectively unregulated, with no formal obligations guiding its administration. If regulations had already existed, why was it necessary to introduce a new oversight in July 2013? From July 2013, the UK's Financial Conduct Authority, the FCA, took over LIBOR regulation, and under the Financial Services Act 2012, knowingly making false or misleading benchmark submissions became a criminal offence. The key issue is that some traders were convicted for actions that were not explicitly illegal at the time. The law criminalizing benchmark manipulation only emerged after the scandal, raising serious concerns about the retrospective application of legal standards. Were these individuals punished under laws that did not exist when the alleged misconduct took place? This situation is deeply concerning, as it exposes a larger problem, pushing individuals to work in unregulated environments only to later prosecute them under broad and ambiguous criminal charges. This issue isn't limited to one field. Industry, like the veterinary profession, face similar risks, where professionals work without clear regulations and later face prosecution under broad charges like fraud or conspiracy, essentially criminalizing routine industry practices that were not only previously accepted, but even encouraged. This kind of legal uncertainty is unacceptable, and the Supreme Court's decision could have far-reaching implications for both financial regulation and broader professional accountability. We extend our best wishes to Mr. Hayes and Mr. Palombo for their upcoming hearings. We'll be keeping a close eye on this case, and we will release a video with an update as soon as the Supreme Court hands down its judgment. That brings us to another important question. How far should we trust the system? Our next news item puts that to the test. What is going on with the CCRC? Do we have a new interim head? The latest news we have is from the debate on compensation discussed earlier, where Andy Slaughter, MP for Hammersmith and Chiswick and chair of the Justice Committee, intervening in the Brian Buckle debate, made a side remark with regard to the CCRC.
I'll just briefly take this opportunity to say to the Minister that we are awaiting the appointment of an interim chair following the removal of the previous chair, or the resignation of the previous chair after a period of time. But we need an interim chair, we need a strong chair. We also need a good process for selecting a permanent chair for that body, and she will know that the Justice Committee has asked to be involved in that process as part of a pre-appointment approval hearing. And I hope that can be done. If she's got anything to say on either of these matters today, that will be most welcome. So, yes, it is right that there are concerns about the process for identifying miscarriage of justice, and I'm pleased to see my little friend, the member for Liverpool Riverside, who very ably chairs the APPG on miscarriages of justice here, and no doubt she will say something about this. Because unless we are clearly identifying cases and doing it in a timely manner, then the issue of compensation is even further down the line, or doesn't even come to the fore. And we've heard that the Law Commission is producing a substantial report. It's a very substantial consultation exercise, some 700 pages so far, which looks at both the way that the CCRC operates, and it correctly says that the test that exists for referring cases is a faulty test, or my word is faulty. What they say is that the test, i.e. that there is a real possibility that referred decisions would not be upheld due to a new argument or evidence not raised in the original or appeal proceedings, means that effectively the CCRC is having to second guess the view of the Court of Appeal. And that's something that they're consulting on, and say that they're provisionally persuaded that the current test should be replaced with a non-predictive one. And the second important change that they are putting forward for consultation is that the CCRC should return to what I think was its original intention of having an investigatory function. In so many cases, evidence is presented to CCRC, it isn't looked at in good time, and when it is looked at, it's looked at purely on the merits of what is submitted and not going behind the case, not seeing whether, in fact, there has been a substantial miscarriage of justice in relation to this.
Kim Johnson, MP for Riverside, Liverpool, also had strong words for the CCRC.
There should be checks and balances in place to ensure that justice is achieved. Instead, we are seeing significant backlogs in the CRC and only a trickle of cases making it through to the Court of Appeal. While the recent resignation of the chair is welcome, we know there are systemic failings and a lack of funding that reveal the need for a complete overhaul, not just a change in leadership. Cases like the Birmingham 4 are still awaiting a decision on their application to appeal. People who believe they can prove they're innocent and who have a right to appeal their convictions are rotting in jail while the system creaks. If the public is to have confidence in the underfunding and struggling criminal justice system, it needs to have confidence that the processes are both fair and appear to be fair. Checks and balances are needed throughout the system, and these need adequate resourcing and support.
The Minister simply responded on the CCRC issues as follows.
This government is committed to ensuring that the process is fair for all involved in the criminal justice system, and a key part of that commitment is the effectiveness of the Criminal Case Review Commission, who carry out the vital work in investigating potential miscarriages of justice. As highlighted by my right honourable friend, the Chair of the Justice Select Committee, the Secretary of State is in the process of recruiting an interim chair, and that is a matter of priority. The interim chair will be tasked with conducting a full and thorough review of how the organisation operates. The findings of this review, together with the final report of the Law Commission, will provide us with the evidence that we need to ensure that any change we make to the system will promote fairness and justice for all involved in the criminal justice proceedings.
Late last month, it was announced that the Justice Committee will question senior leaders of the Criminal Cases Review Commission during a one-off evidence session on Tuesday, the 1st of April, on the work of the CCRC. The Justice Committee conducts accountability hearings for a number of bodies, including the CCRC. The last time the CCRC appeared before the committee was on the 25th of May 2021. Andy Slaughters commented, "This forthcoming evidence session is a timely opportunity to question the CCRC leadership following the departure of its chair and wider reports of multiple challenges facing the CCRC and its management. Members will be seeking answers to a wide-ranging set of questions. Given the circumstances of Ms. Pitcher's resignation, action must be taken to rebuild the reputation of the CCRC and repair some of the damage to public trust in the organisation that has been done during Ms. Pitcher's time as chair." The independent review of the CCRC's handling of the Andrew Malkinson's case by Chris Helly KC was damning. It is vital that the leadership of the CCRC are held to account for the response to these findings, and that the committee has the opportunity to scrutinise the CCRC's other work. We will cover the outcome of the evidence session in next month's news session. In the world of legal battles, our next story demonstrates how the plot continues to thicken when it comes to justice. Despite new medical evidence from an international panel of 14 highly respected experts in neonatology and pediatrics, who concluded they could not find evidence of murder, Lucy Letby's case remains at a standstill. Even with the strength of these expert opinions, progress has been minimal, raising serious concerns about how the justice system handles complex medical evidence and whether a fair reassessment of her case is genuinely taking place. This ongoing stagnation fuels more debate, leaving many to question what it will take for this case to gain the momentum it urgently needs. On Monday, the 17th of March 2025, as the Thirlwall inquiry resumed for closing submissions, a group of protesters gathered outside Liverpool Town Hall calling for the suspension of the inquiry. The demonstrations was organised by the Partisan Defence Committee, who urged that the inquiry be suspended, warning that suppressing the voices of nurses, many of whom must remain anonymous due to fears of retaliation, directly endangers patients. They weren't alone in seeing the resumption of the Thirlwall inquiry as a chance for momentum to build. Lucy Letby's legal team also on the 17th of March 2025 made an application to the chair that the inquiry be suspended. But they were not the only one. An application to pause the inquiry had already been made by the Countess of Chester Hospital's executives, Ian Harvey, Alison Kelly, Anthony Chambers and Susan Atkinson, on the 21st of February 2025. Lady Justice Thirlwall sought to deal with that application at the hearing for closing submissions and directed that the letter be distributed to all court participants and for the court participants to add their view of the application in their closing submissions. Request to pause the inquiry came from other quarters, as mentioned by Lady Justice Thirlwall.
On the following Friday, the 28th of February, in the early evening, Mr. David Davis, MP, wrote to me also seeking a pause in the inquiry.
So, starting with Lucy Letby's solicitor application first, it essentially asked Lady Justice Thirlwall to suspend the inquiry under Section 13 of the Inquiries Act 2005, stating that the combination of several compelling reports from international experts, the failure by the prosecution to properly disclose material relevant to the defence, and analysis by leading statisticians conclusively showing the jury were likely to be misled when they were told of spikes in deaths and shown an unreliable staff rota, and a lead prosecution expert who has changed his position on critical factors since the trial will show that any final report from the inquiry or recommendations will not only be redundant but likely unreliable. And continued, the terms of reference of the inquiry were drafted on the basis that Lucy Letby is guilty and therefore will not consider any evidence which contradicts this. If, given the overwhelming evidence that the convictions are unsafe, they are overturned, then any report produced by the inquiry will be based on the wrong premise. This error will pollute the very nature of the report, and any conclusion or indeed recommendations will be of little value. In short, it will defeat the purpose of a public inquiry to fully and fearlessly understand the circumstances in which the babies died or became unwell. Essentially, Lady Justice Thirlwall dismissed the letter on a technicality, arguing that it was misdirected by requesting the suspension of the inquiry under Section 13 of the Inquiries Act 2005, a provision that applies to the Secretary of State rather than to her. Her response was, in our view, harsh, as she could have alternatively considered it under Section 17, just as she did with the request from the NHS executives. However, by choosing not to do so, it appears she found it more convenient to dismiss the letter outright rather than engaging with its substantive arguments. It is important to emphasise, though, that in practical terms, whether Lady Justice Thirlwall had fully considered the substance of the letter would have made little difference to the outcome. Her handling of the application submitted by the executive of the Countess of Chester Hospital, which we will examine next, makes it clear that the position on such requests was already firmly established. This suggests that even if she had engaged with the letter more thoroughly, the end result would likely have remained unchanged. Now, turning to the application submitted by the executives of the Countess of Chester Hospital. In essence, they held that the terms of the reference for the inquiry are based on the assumption that Lucy Letby's criminal actions were the cause of the deaths and unexplained collapses of babies in the Countess of Chester Hospital's neonatal unit between June 2015 and June 2016. This assumption has shaped every aspect of the inquiry, including its investigation, evidence gathering, and witness questioning. However, emerging evidence suggests that alternative explanations such as poor clinical management, inadequate care, and natural causes may have played a role. Yet these possibilities have not been properly explored. The inquiry did not seek independent expert opinions on the quality of medical care, instead treating those responsible for clinical management as unquestioned experts. Meanwhile, individuals who suggested alternative explanations were subjected to critical scrutiny for not accepting Letby's guilt. They said, to continue to make findings on the evidence heard, given the filter through which it was drawn, it is to breach the duty to act fairly to those individuals and witnesses as required under Section 17, subsection 3 of the Inquiries Act 2005. It also defeats the very purpose of the public inquiry, which must be to fully and fearlessly understand the circumstances in which those baby came to die or suffer unexplained collapses. If there is evidence to indicate that there is an alternative explanation, then it would be wrong for the public inquiry to ignore it. Nor would it be appropriate, without more, to make a determination about its evidential value. This is now a matter for the CCRC until there is clarity as to Ms. Letby's involvement as determined by proper and legitimate appellate process. The proceedings must be paused. Without descending into the legal arguments as to whether she has or not a power to pause the inquiry and the nuances of Section 13 and Section 17 of the Inquiries Act 2005, in essence, Lady Justice Thirlwell accepted, for the purpose of dealing with this application, that she has a duty to pause the inquiry under Section 17, subsection 3, which states, in making any decision as to the procedure or conduct of an inquiry, the chairman must act with fairness and with regard also to the need to avoid any unnecessary cost, whether to public funds or to witnesses or others. And she ruled as follows.
I express no view on the merits of the application to the CCRC. It is clear that this will be a very lengthy process for the CCRC, and were a referral to take place, the Court of Appeal Criminal Division. It is inevitable that the pause being sought is of a length which is entirely outside my control, but it appears on the face of it to be a very lengthy one. This is rather more than an adjournment granted, for example, to allow the parties to deal with disclosure or to support a witness, and so on. The sorts of pauses which are entirely routine in inquiries. This increasingly looks like an effective suspension.
She then turned to rule on the two limbs of the submission as per Section 17, namely cost on one end and fairness on the other. In relation to costs, she emphasized that the need to avoid unnecessary cost, a priority since her appointment as chair. The inquiry had completed its evidence phase ahead of schedule, reducing expenses. The remaining tasks, report writing, issuing warning letters and publication, would incur some costs, but the bulk of the expenditures had already been made. She argued that delaying the report would increase costs, as longer gaps between evidence completion and judgment tend to prolong the process. A pause would require maintaining a reduced secretariat, with no guarantee of retaining staff, potentially leading to the costly formation of a new team. Considering these factors, she determined that the need to avoid the unnecessary costs did not justify granting the application to pose the inquiry. In relation to fairness, this is what she said.
That leaves then the question of fairness. I have set out what is required of me. There was no suggestion from any of the core participants at the time I opened the hearings that it was unfair to observe that the convictions stood, nor was it suggested that it was unfair to work on the basis of the convictions, notwithstanding what I then described as noise. The process of the inquiry has been conspicuously fair. Every core participant has been sent in advance an outline of the questions to be asked, the documents to be looked at, and no one has been taken by surprise by the documents. All counsel had the opportunity to ask questions of their clients and of other witnesses. All of any such requests were agreed by counsel to the inquiry, and I wasn't required to adjudicate on a single application. The inquiry does not become unfair because there is a possibility, as is asserted, that all the convictions are unsafe. It's important to repeat that which I've said on a number of earlier occasions. I completely accept and to have approached the inquiry in this way, that is, that it is essential to guard against hindsight when judging the actions of people 8, 9, and 10 years ago. That's not going to change once I move into the report writing stage. As I have said before, it is not the actions of Lucy Letby that I am scrutinising. It is the actions of all those who were in the hospital and within the terms of reference, whose actions I am reviewing, what they did at the time, in the light of what they knew at the time, and in the light of what they should have known at the time. There are already large numbers of concessions about what wasn't done that should have been done. Those significant concessions come from the organisations, the hospital, including the doctors and the managers, have conceded that they have made a number of concessions, including that they should have communicated better with parents and should have provided pastoral care for the consultants. But perhaps principal and most obvious amongst the concessions made by just about everyone is the acknowledgement that there was a total failure of safeguarding at every level, and that will not change. It's a matter which has been debated at some length in the course of the inquiry, and one that it seems to me inevitably will feature in any report. There were some submissions that one type of witness was treated differently from other types of witness, doctors versus managers. I'm not going to make any observations about that. It seems to me that's appropriately dealt with in the course of a report, but not at this stage when I'm reviewing the whole of the evidence. I remind myself of a submission made by a number of people that fairness to all the parties is required, not just to a single set of core participants. I'm not satisfied that there is any unfairness in the current situation. I'm satisfied that the process has been fair. At the very end of her submissions, Ms. Blackwell suggested that I might consider a hybrid approach. This would be to publish parts A and C, but not part B, publish the report in respect of parts A and C, but not part B, until the resolution of the criminal cases. I accept that from the perspective of her clients, Part B is the most contentious and potentially difficult. But the reason why Herculean efforts were made by everyone to be ready for Part B so that it could be heard immediately after Part A and before Part C was because they flow one from the other. The experiences of the parents can't be separated from the actions of the people in the hospital. Equally importantly, recommendations are bound to come out of my findings. I've already said as much. If Part B were omitted, there is a risk that recommendations lose their anchoring in the facts, and also, it seems to me it's a point well made, that they can lose their impetus for not being attached to findings of facts. Accordingly, subject to a review of my notes to ensure that I've included everything for all the reasons that I have rehearsed during the course of this somewhat lengthy extempore judgment, the application is refused. I should say that, of course, the question of the timing of the publication of the report is, as always, a matter for me, and I will always keep that under review, as I would do in any other inquiry.
While I acknowledge that Lady Thirlwall is bound by the terms of reference and her decision is legally justifiable, it is nevertheless disappointing that procedural and convenience-based arguments have once again taken precedence over common sense and the broader pursuit of justice. From a lay person's perspective, this reinforces the perception that legal technicalities often overshadow the fundamental need for fairness and a thorough examination of all relevant factors. It's also worth highlighting a remark made by Mr. Baker KC, as recalled by Lady Justice Thirlwall in her ruling, where he stated, whatever side of the debate people are on, people should remember that the dead and harmed are not public property to be dissected on television or on the internet. She cites this statement immediately after referencing the press conference organized by the defense team. However, I find this comment to be highly unfair, as it seems Mr. Baker KC may have overlooked the extensive media coverage this case received immediately following the first trial, particularly from police and prosecution witnesses, which included Daily Mail podcasts in August and September 2023, including discussion with the police officer in charge of the investigation and a police officer who interviewed Letby, a Talk TV recording of an interview with one of the main prosecution witnesses, BBC Panorama documentary with interviews with parents, police officers, and a doctor from the hospital. Another point is the timing of a police announcement made on the 13th of March 2025. Cheshire Police confirmed that the scope of their investigation had been expanded to include gross negligence manslaughter. While corporate manslaughter refers to a company's gross negligence leading to someone's death, gross negligence manslaughter applies to individuals within the organization or their actions. The timing of this announcement, just days before the Thirlwall inquiry was set to resume, and Lady Thirlwall was to decide on the application from Countess of Chester Hospital's executives to suspend the inquiry, has raised serious questions. Lucy Letby's counsel Mark MacDonald expressed his astonishment, stating it is astonishing that on the eve of the legal arguments to stop the Thirlwall inquiry, the police have decided to issue a press release discussing gross negligence manslaughter. It seems that with every attempt by the defence to address the clear flaws in this case, there is a corresponding effort to bolster and reinforce the prosecution's narrative. Will this case ever gain the momentum it desperately requires? Let's continue the debate in the comments below. Before we wrap up, we have two important government consultations that have just been launched, both crucial developments that we will dive into in a dedicated future video. The first, launched on the 6th of March, focuses on reforming private prosecutions and the single justice procedure, with a deadline of 8th of May 2025. The second, announced in January, is a call for evidence on the use of software-generated evidence in criminal trials, closing on the 15th of April 2025. Both are linked below. A full breakdown is coming up soon, so stay tuned for that. And speaking of in-depth discussions, we have an exciting podcast coming up where we will be exploring the shifting landscape of miscarriages of justice and the new challenges facing those wrongly convicted today. We have lined up two mystery guests you won't want to miss. So be sure to watch this space. As always, don't forget to like, share and subscribe, and most importantly, keep the conversation going in the comments below. That lively debate is where the real groundwork for reform begins. Join us again as we sit and rise in this unique trial.